Maybe there's just some inherent thing that we remember.
Yeah.
That's just visually. That's great.
We'll see. Well, good morning, everybody. I'm supposed to do a health and safety instruction. So I'll very briefly say that if there's any disasters, we go out to the door that you came in and follow instructions of the staff and assemble outside of the space house until the staff have done their reconciliation. Otherwise, I'd toilets, etc. out the door at the far end of the room from me and to your left. And otherwise, I would just ask that everybody just check their cell phones are off, and we're underway. I think Ms. Lawrence.
Kia ora, everybody. I've got the opening statement. I've prepared an opening statement, which Kate's just sitting around, that just summarises the points that I think are still in contention in relation to the definitions for the RPS. If I haven't mentioned an issue in this statement that I had raised in my section 42 or supplementary evidence, then I consider that that is an issue that's either been resolved or is relatively insignificant. Just want to draw the panel's attention to, I know you're aware, but that there is a number of definitions in the RPS that have been addressed by the relevant topic chapter and supplementary evidence and subsequent 42A reports. And as such, I confirm that my statement today only relates to those definitions which is dealt with within the section 42A report. There is a table in my section 42A report which identifies where the different chapters are picking up other definitions, so that may be helpful for the panel going forward in remaining hearing weeks. So as I said, there are still a few definitions based on evidence that has been received that are still in contention, and I'll run through those now. The first one is minimise. Contention remains around whether this term should be defined within the RPS. Those who desire to see the term defined cite the recent interim Environment Court decision on the proposed Southland Land and Water Plan to include the definition and also to remove ambiguity in the use of its term by providing a clear direction. The planning evidence of the energy providers which request a new suite of standalone energy provisions also requests that a definition for minimise be included. However, there are still some supporters submitted support for my recommendation in the section 42A to reject the request to define the term, and this is as it is inconsequential to the interpretation of the relevant policy provisions. The next one is precautionary approach. There remains a desire from some submitters to see precautionary approach defined to provide clarity as to what is entailed when applying the precautionary approach. There are some submitters that do support my 42A report recommendation to reject that request to define the term. They agree that it's a well understood term and that there's sufficient context where it is used within the RPS. And this is particularly in light of the amendments that have been made to the IMP6, which is in the October version of the RPS. And will be dealt with obviously in your hearing week for the IM chapter, but the review of that policy now provides much clearer direction, I believe, into how precautionary approach is applied within the RPS. Then there's receiving environment. Although this term has been applied very narrowly within the RPS, a request remains to remove the definition. The concern here is that the definition as it's currently applied does not appropriately provide direction as to what is understood to be a receiving environment for the resource management activities beyond those which are reflected in the current definition. So that definition is pulled from the NPS FM, so it has a very narrow application in relation to freshwater. So the submitter's concerns here is about providing the direction for other receiving environments in the resource management framework. Then there's restore. Contention remains around whether this term should be defined within the RPS. Those who desire to see the term defined cite provision of clarity as their reasoning. There is support though for my section 42A recommendation to reject the request to define the term. They agree that there is common meaning and it's a well understood term. Furthermore, there is a suggested definition by one submitter, and that's considered to introduce some subjective language. So they're the definitions which I believe are still points of contention between submitters and my section, between themselves, but also with my recommendations of my section 42A. There are some points of clarification though that I thought might be helpful to make to the panel that have been sought in recent evidence, and I'll run through those now. The first one is lifeline utilities. So there's clarification is sought to the interpretation of lifeline utilities, and specifically its reference to the CDEM Act. I refer the panel to my supplementary evidence, which confirms the interpretation of the application as it relates to the definition of lifeline utilities is in line with the evidence that has been prepared by Port of Otago. Essential human health. The inclusion of this definition relates to the emphasis given to food production in Otago and its link to wellbeing within the RPS. Is not currently a term that is used within the document, but should an alternative approach be taken in the introduction and general themes, and also part 2 of the RPS, then approach to this definition remains in contention. In that instance, I think in particular consideration should be given to how the definition would provide additional clarity that is not already present in providing for health and wellbeing as required by section 5 of the RMA. Sensitive activities, there's support for the definition as it applies to the EIT chapter. The approach to defining sensitive activities remains in contention as it relates to the application of the term in the urban form and development chapter. My recommendation in supplementary evidence was to reverse my original section 42A recommendation, which was to provide a specific definition for sensitive activities as they apply to those provisions in the UFD chapter. This recommendation in my supplementary evidence was consequential to the term being removed from those relevant provisions as per supplementary evidence of Ms. Elizabeth White. However, there is opposition to the changes to those UFD provisions, and so therefore there remains the question as to whether the term sensitive activities will be required if it is reinstated back into those UFD provisions. In this instance, submitters still seek to changes to provide a more descriptive definition to apply to the UFD provisions than what I had actually recommended in my section 42A report. And finally, waterways. Submitters originally requested a definition be provided for waterways, but now they actually request that the term be removed, an alternative term, defined term such as water bodies be used as its replacement. This request requires consideration across the document as to the appropriateness of that suggested term, as opposed to actually the consideration through this chapter as to a definition being provided for waterways. I'm happy to answer any questions or queries that the panel may have.
Thank you, Ms. Hawkins.
On this today, yeah, just one question around receiving environment, and I understand that the definition that you've used in the interpretation section here is now, and it's just referring to the NPSFM. I mean, are you reasonably confident that you haven't referred to that term anywhere else in the document in relation to anything else other than receiving effects on water bodies?
Yeah, we have checked through the document quite a few times, so I am confident in that. I guess in my opinion, I think it still needs to be a term that is defined in relation to how we do use it. I can appreciate, I guess, the concerns of the submitter in terms of what direction this RPS may provide to lower order plans and the broader resource management issues of receiving environment that it might need to give direction to. But I don't think that should respond by removing the definition. There probably could be some further clarification in the definition section that it does specifically provide direction to its limited application. So that it's, I guess, then the RPS is leaving it open for then district plans to be constrained by that if they're considering receiving environment issues in other aspects. But it has only been used in the LF and the C chapter.
Yeah. And I suppose, my concern is others picking it up or it being referred to in slightly different context based on the definition in the RPS if it's not made really clear that it's only in relation to those freshwater matters where the term is used. Yeah, I can see the issue there. Thank you. Yeah.
I don't have any question. No, I don't have any question.
Got a lot of underlining in my copy of your report, but I don't see any questions. Nothing has jumped out today. So thank you very much for talking.
Thank you.
I think we're at a stage where Mr. Adams was to be called.
Yes. I think Victoria from Waiteki is
Oh, right.
here online, is that right?
Yes.
Oh, in person, apologies, and wishes to be heard.
Thank you. Good morning. If you could introduce yourself. And
Good
the
morning.
floor is yours.
My name is Victoria van der Speek. I'm currently employed as Principal Advisor at Waiteki District Council. I have 21 years working experience in the resource management space, and I'm representing Waiteki District Council's interests at this hearing. My evidence considers the need for a regional carbon forestry definition, supports the approach taken by ORC through its Section 42A report to a number of points raised by Waiteki District Council in its original submission, and confirms that Waiteki District Council does not wish to advance the remainder of points raised in its original submission that were not addressed through ORC's Section 42A report. In relation to a regional definition for carbon forestry, and following discussions at the proposed RPS pre-hearing in June 2022, WDC led the development of a draft regional definition for carbon forestry along with 3 other parties. The intent of the regional definition for carbon forestry was to apply consistent terminology and management approaches to carbon forestry in Otago. Subsequent to this, in October 2022, the Ministry for Primary Industries released a discussion paper around national directions for exotic carbon forestry and afforestation, which included a draft definition for exotic carbon forestry. I consider that the draft definition for exotic carbon forestry contained in MPI's discussion paper is fit for purpose, and if adopted and included within the National Environmental Standard for Plantation Forestry, would provide sufficient direction to apply consistent terminology and management approaches for carbon forestry in Otago. However, if a national definition for carbon forestry is not adopted, then I consider that it would be valuable to continue to pursue a regional definition through the Otago Regional Policy Statement. That concludes my evidence. Happy to take any questions.
Just before I open the panel for any questions, could you just have you got that definition in front of you?
Sorry, I don't. I was looking to talk about that today.
That's right. So what stage is that consultation process at, and how much certainty or otherwise is there as to whether it actually gets gazetted?
At this stage, there's a few unknowns there. I'm not really sure quite the anticipated timeframes, the outcomes of that process. In terms of uncertainty, no, there's not certainty. That was definite directions, and yeah, it's going in the right direction. But no, we don't have certainty at this point that it will actually eventuate.
Okay, thank you.
Yeah, I suppose what was the process towards MPI and MFB pulling that discussion paper together and developing that definition? Did that have wide input from the sector and councils and others and pulling that draft or that discussion paper definition together?
Yes, I understand it did have quite a wide input from the sector. There was a working group established across councils, and Waitaki was involved a little bit through piecing some of that.
Thank you.
Thank you. Good morning, Victoria. I just really, I was going to ask about the timing on the plantation forestry rigs as well, but the other point that Waitaki raises around the resourcing requirements, and one of the policies making it mandatory that you do various things. I think you raised in the context of iwi functions, etc. And we had Mr. Garlick from DCC, who I also think acts for Waitaki on various things. He outlined the RPS in the context of the planning environment framework, and then local authorities, other roles under the Local Act and Freedom Powers Act and all that sort of stuff. So do you have any further comment to add to that? He was basically saying that there are other considerations here. We can't, an RPS can't direct that sort of thing because it's not really its role.
Yeah, I'm not really sure I've got anything to add further on that. It was an issue we sort of flagged earlier on, but recognise that the RPS is not a place potentially to address the resourcing side. Probably other mechanisms to do that.
I think Mr. Garbutt said maybe it should be a encourage. In reality, councils do it anyway, but it's just having it made mandatory was the concern.
Like anything, particularly the smaller authority, resourcing is always an issue. That could be a good option to slightly softer terminology there.
So you also raised there is a number of submission points that weren't addressed by the council planning reports. I do have your submission here. I was just wondering, was there anything in there that you wanted to touch on? A lot of it seemed to relate to section 32 sort of matters, but is there anything you wanted to add in relation to those complaints?
No, there's anything to add. They weren't. They're reasonably minor in nature. Happy to leave those.
Thank you.
Just a very general question, really. Is carbon forestry, permanent planting becoming a major issue in the Waitaki District Council area or not?
Yes, it is. I guess that's the reason why we raised this issue. It's in the last probably 2 to 3 years, it's really increased.
So major pastoral stations being planted or not?
Correct. There's been at least 2 of recent times, quite big farms that have been converted,
right,
or in the process of being converted.
And on the flip side, wilding pines a major issue in Waitaki District Council's area.
They continue to be because of quite further up the Waitaki Valley, bordering on the Mackenzie Basin.
And do you
that's more in the Canterbury region in that particular area.
Do you have an active trust? For example, in Marwood, there's a very active trust which has been reasonably successful in accessing some national government funding for wilding pine removal. Is there some similar sort of community-based trust operating here, or is it something that's left to the council?
I'm not aware of a trust similar to Melbourne. I'm not aware of that.
Right. And what's the council's own position in terms of its role or otherwise in terms of wilding pine removal? Does it have one? Yeah.
It's reasonably weak, I think, at this stage, but it is being addressed through we've got a district plan review at the moment. So it's kind of being looked at, considered through that process. I guess because we're a split district, as in we've got 2 different regions in our district, that makes it quite complicated. You know, we've got more population in the Otago region, but a bigger land area in Canterbury. So the approach is a little bit different here. That makes it a little bit more challenging.
Okay, thank you.
Thank you.
Must be nice and coming to Dunedin rather than Christchurch. I just see that
Well, you'll
for
be
the
on-
commissioner down.
Thank you.
Thank you, Mr. Smith.
If I could assist in paragraph 15. Bad specs evidence, there's a link to the MPI discussion paper, which contains the definition.
That's a matter that's going to crop up later on, isn't it?
Thank you. Mr. Evans. Yes. Morning, Mr. Adams.
Good morning.
Thank you for having to hold on this long to the questions posed to you, but there will be, I suspect, a number of questions from the panel, and we'll revert back to mention those with you. Very good. Not a penalty check.
Yeah. My computer's playing up.
Ellen?
You owe me that. Taking my time getting my thoughts. Morning, James. I guess you've been sitting here listening to our conversations around definitions of Papakanga and Maryland, the concerns of the DCC and how that may play out. And we've explored a little bit with some of the runaka around what the commercial element may look like. And it kind of has occurred to me, well, is it an issue to have that in that definition when that conversation is going to have to take place at the district plan level anyway? What's proposed here is an enabling approach, but as I think Cedric McIntyre pointed out, enabling takes different forms. You know, you can be control of discretion as long as you're recognised, provided for some sort of pathway that's considered enabling. So I'm wondering the relevance of the debate around the insertion of commercial in that like a definition. Do you have any comment around that?
Largely, I've approached these definitions with a view to the fact that these terms belong to mana whenua, and so I've largely accepted what they've included in those definitions. You might note in my section 42 evidence, I did at first say that I wasn't so interested in including commercial within that. I think the original submission for inclusion of that term came from the Cane whānau, yeah. And I felt at that stage that what they were proposing didn't seem to match up with the discussions that I'd had to that date with Kaitaku through Okaha and Te Ao Marama. However, when we went back to pre-hearing discussions and had a more fulsome discussion around that, they were supportive of that definition, and I saw the unity in that. And I understood from that discussion that the importance of including commercial in that was the risk that I think Sandra laid out, that definition might risks or definitions of papakaiaka and traditional activities risks being pushed back to traditional forms of those activities.
Yeah.
And they've expressed throughout time the view that their tikaka moves on and moves with the times, both backwards and forwards. And I recognized and agreed with the idea that including the commercial element within that definition was a nod to the fact that that would be a part of the village that they are sort of proposing to include under this definition.
And I guess probably what entered into the thinking of Elsa was, as we've discussed, Silna land is slightly different to the native reserves, the ancestral sort of sites, because of how it was, how it came about. I think so you wouldn't have any concern extending it into that realm for that reason, or comfortable with that sort of view.
I'm not sure. I think I
Probably
understand.
didn't articulate
That's
it.
all right.
There's just a difference in terms of how those lands came about, and still
Yes.
was actually provided, set aside for economic purposes.
Yes.
I think that was probably the driver.
Mm.
Yeah. So effectively what I'm saying is sort of tends to lend more weight to actually have reference to commercial activity in that bundle.
Yeah, I don't think I am concerned by that. These both the use of multi-land provision that sort of activates the multi-land definition really in WP4, and the papakaiaka definition include reference back to practices that are within the realm of tikaka and kawa, and it's my belief that those practices put, as I think Sandra and Maria explained more ably than I will, put a frame around the kind of practices that are expected and the way that those would be practiced. So I'm comfortable with that.
Yeah, and I guess that concern that DCC raised around the natural justice issue flows out of that definition of married land. Have you given any thought to that? Because I think it's your number 7 that we've referred to, owned by a person or persons that evidence of kaitahu, whakapapa, etc. But kaitahu actually want to extend that even further to any land owned by primates or the rumatas. And the concern that Paul Freeland had, and others probably expressed this, when you can't just have a block of land that may be currently rural, but suddenly the land ownership changes. So suddenly that becomes something different. Now it becomes a rural settlement zone, something like that. Not that that's how it would actually pan out, because you still would have to go through a process, I would have thought, unless they had a provision in the plan that allowed that. Some sort of floating zone that when the land ownership changes, then suddenly it's rezoned. Everything else around it is cut out of that conversation about what effects it may have on them. Did you have any comment around those issues?
I recognise the issues that Paul raises. I think there are certain amounts of multi-land that are known, and those could be met. It's possible because we have with hazards, for instance, we know that hazards can crop up and be identified, and for that reason, some of those areas sit outside the plan and are updated through time. And so perhaps for new areas of land, that kind of solution would be possible. I think as has also been expressed, the areas of Māori land are huge and extensive. And like you say, I think this would be particularized at a district plan level, how you would approach that issue.
Yeah, thinking ahead to a district plan preparation and how this might work, I would see that, yes, we've got these ones identified, so in these cases, we could create a zone for them. But if, say, if they had clauses, one of the Kaitahu submission and 7 of yours, if that is activated, then if you want to go down that path, you have to go through a consent process. So I don't think it's a big deal myself in terms of how you handle it, but it's more the barriers that are concerned to people like cane farming and stuff like that, who may get involved in that process when all those other Section 6 matters are in play. So that sort of leads to the primacy issue. I was just wondering whether you'd given any sort of consideration to that around whether you're comfortable with how Sandra's promoted the connections within the plan, or because I think Elsa and Co were, and it will probably Maria also were kind of pushing for a statement, something that sort of elevated Section 6E above. Whether you can do that, I don't know. Didn't they thought? I think Murray Brown said no, you shouldn't really do that. It should be waiting exercises. But that takes us back to the problems we've already experienced with that man.
Yes, and I think Sandra's approach to that addresses that by letting Kaitahu lead those processes. And so it promotes and it's sort of part of the purpose of the whole set of provisions in the mana whenua section is to promote an ongoing discussion, to plant, I think as Elsa said, plant a pō in the ground, this is where we are, and then invite ongoing conversation around all of those issues. So it's going to occur through district plans processes, yes, and through partnership between the organisations. I'm not a fan of a blanket primacy approach. I think there's a integration between provisions in the RPS that relies on the wording used. I'm not a fan of just stepping outside that for one particular issue. And so I appreciate the way that Sandra's wording has provided for that whilst still tying the plan together and keeping its integrity.
Yeah. Thank you.
Thank you.
Thank you, Dave. Just when you think you've got to write the technology, it turns you upside down.
I never feel it.
Now, I'm just going to run a couple of things past you and see if you agree with me or not. And it's partly to do with what I think I've read over the last couple of days from 2 points of view, from the council point of view and from Ngaitahi's point of view, and where they match or where they don't match. Seems to me that if we were to make a list of the key issues for Kaitahu at the moment, generally speaking anyway, that in my viewing, what I'm hearing is that from Kaitahu is that mahinga kai is probably at the top of their list. Whereas other lists see mahinga kai, but not to the same extent. I mean, there were other less, what I call tikanga-based issues that exercise other people's minds more than they do. Would that be a fair comment from your point of view?
just to make sure I understand that Kaitahu are coming at this strongly from a point of view of preserving mahikakai, and other people are less concerned with that as the entry point to the issues. Is that?
Yeah. There are bits to the Mahinkai issue that I want to get to anyway, but as a general thing that, I mean, I listened to Edward and to Matt and Brendan and co. Now, I understand the fact that they're coming from a particular point of view. I mean, Brendan comes from a marine fisheries point of view. Edward has a more kind of Runanga Ngaitahu wide perspective, sort of almost at a management level. And but their concerns are more about recovery of Māori, mahingakai, protection of. I mean, I often wonder sometimes if some of the degradations they refer to is irrecoverable anyway. That kind, you know. So there's, but the sentiment or the philosophical underpinning for them is still around mahingakai. If you can sort that out for us, the rest of it sort of. Been in my most cynical moment, I would say the rest of it is for you guys to sort out. In a sense.
Yeah.
That's kind of what they're saying. Do you read it the same way?
I think Elsa expressed it really, really well when she said that this is more than theoretical, it's practical, and it's about actual reconnection and actually being there
that's
in
what
these
I'm sort of
places.
getting at.
And I think I do think that's really important. I think that's part of what we're trying to do here. When I talk about having an ongoing conversation, conversation is not enough. It's about having an ongoing partnership and relationship that recognizes those things and those facets of identity and how much they matter. I know from my perspective, I'm never going to quite understand that properly in an internal way, but we can certainly recognize that through the way that we try and do things in the policy statement.
Yeah. And another takeaway message for me is that for the most part, the Aitahu Council relationship has been a good one. I don't see any real bad spots there. And so in a sense, we're looking at, or you are looking at, or Kaitai are looking at improving what's already a reasonably good situation between the two parties, if I can put it that way.
Yes. Yeah. I hope that we can keep growing closer over time. And I have to recognize in that, I think Edward laid it out very cleanly, that a lot of the effort into fixing that relationship for a long time was coming from Kaitahu.
Yeah.
That they were building the systems to engage and do all that thing and do all that stuff. And it's important that the council reciprocates that and continues to do that over time. I hope that's what we continue to do.
Hey, you just jumped ahead of me a wee bit. That's what I was leaning to now, sort of who was putting the most effort into this partnership building scenario or model that everyone is alluding to at the moment. Just to change tack a wee bit, to get back to the reo question, use of and all that sort of stuff. And it was the issue around tuku iho. What's your take on that?
I have to admit that I don't fully understand the ambit of that term. I relate it to so it's been a while since I addressed it, but my understanding is that it relates to the importance of ancestry and those ancestral connections through time. It emerged, and I was And I mentioned that in my section 42 to discuss with Kaitahu later on. And when we actually looked at it, the term was only used, I think, once in the original form of the RPS, and then inserted a couple of other times purely to support that lowly application the first time. And so Kaitahu thought in the end it was probably easiest to take it out because the expression was there, but I would certainly be open to inserting it again if it was felt necessary, and if we probably in the same way we have for other terms, put in a bit of a narrative description of what it relates to and what it means in the context of the RPS.
Yeah, which is part of the conversation that Maria and I had, roughly, further defining or more closely defining some of the use of some of the words like mataraka, for instance. Tuku, Tonga tuku is one of those as well, and I understand it. And I think some purists would bemoan the loss of not using phrases like Tonga tuku, even although, again, the purists might further define that in more detail in a different way. And I think that's, after I had the conversation with Maria, I thought that it was one of the issues that I would have liked to have expanded on a bit more, but I didn't really. The point you make about partnership and allowing or enabling Kaitahu to, like the phrase I use, is more meaningfully engage with the system, which you would hope an RPS, or even at the district planning level, would foster even more than they do at the moment. Do you think that's a realistic and meaningful route down which the council and Ngaitahu can go together? Part of my reason for saying that is those words have been there for a long time.
Okay. Yes, I agree. It's been said for a long time. Yes. And I'd like to see it put more into action. And part of that is you can only put so much in a plan. I think part of that needs to come from the relationship. And part of the genesis of this section is that in some small way it provides a platform for that relationship to continue and sets out some expectations for that relationship through including kaitahu in decision making and providing resource, particularly on the resourcing issue. I know that's been something that kaitahu have been raising repeatedly for a long time, that it's all well and good to have a process that everybody has access to, but if you can't actually muster the resources, either not necessarily financially, but also the knowledge and the technical knowledge to involve yourself, and hence Okaha and Taumarama have arisen. And I think I understood her correctly, also Kane saying for her whānau to participate in the settlement legislation, they had to sell off land to have enough money to participate, which I would guess is the very land that they're trying to protect and use. And just the unfairness of that sort of resonates pretty heavily. And I think these processes are complex and somewhat arcane, and they're going to be, because they cover complex issues. But when that's the case, we need to be supporting the people who need to be there to be at the table. And that can take a number of terms. I know there was some discussion about resourcing in financial terms, and there might be some of that. I know we did discuss whether council or whether the RPS could actually instruct resourcing at that level. I think all the policies in the RPS will have some impact on what the council have to do. So to some extent, there is always a resourcing implication there. When we came up with the policy and the RPS, I'll just have to remind myself which number it is. I think it's MWM4. Yeah, around resourcing. We weren't necessarily talking about financial resourcing. We're talking about that whole gamut of what resourcing may cover. So sorry, I'm wobbling a bit here, but I think the upshot is that I think that resourcing Kahu to be involved in a realistic way is important.
One of the relationships that I was unaware of, very little insight into, was the relationship with both Aukaha and Te Ao Marama. I hadn't quite appreciated the extent to which there's interaction between. I mean, I've been aware of both of the organizations, but I get the sense that, I mean, their involvement in helping to do some of the drafting and all that sort of stuff, in a sense, took my own thinking to a different level. Because I was quite encouraged, to say the least. This relationship has flourished to that extent. But having said that, I did wonder, I mean, that's almost an assumption that it's been going for a while, that the relationship has been a really good one for a long time. Am I right in saying that?
It's improved greatly.
Eh?
Yeah.
It is improved greatly.
Yeah, that's kind of what I'm.
There used to be a bit of a battle.
That yeah, well, that's when I first ever sort of kind of saw it. You know, it wasn't that nice, you know, shaking hands sort of stuff. It was for
Yeah, I know.
that kind of stuff.
It's really built over time, and I think that connection is important because you've got the sort of mana-to-mana discussions that happen at council or level, but the sort, I guess you might call them the engine room discussions between policy analysts are also really important. And Kaha and Te Ao Marama have been really instrumental in helping us sort of develop these sections. And in some ways, I feel a bit rich calling myself an author. I feel more like I'm a sort of caretaker for the ideas that are coming in that sense.
Yeah, I mean, that's really encouraging from my point of view. So it's kind of it fits one of those cogs that often don't get oiled. You know what I mean? They just don't. There's always a standoff on them. I guess what I'm saying is the standoff isn't so evident anymore in my book anyway. There's more cohesion, talking to each other, and even some of the questions we've been throwing around over the last couple of days. I always thought, if I can throw that question there, it's going to rebound over here somewhere, and in a sort of nice way, if I can use that phrase.
Just before you go off there, Mr. Chair, it's all right.
Yeah,
Just from my experience of practicing in this area around the resourcing issue, I would, despite the comments around the mandatory nature of that, I think it's actually critical that the Kaha and Koa are actually almost funded by the councils, because we're in a position at the moment where, like everyone, losing staff, don't have the appropriate staff to come in, and I have a number of applications in front of a car that can't get dealt with because they don't have the funding and resources to deal with it. And it's not just an OKA problem, because that flows on into the whole resource consent process people start getting crabby at everyone, including the DCC and ORC, because they can't deal with their consent roads because they can't, it doesn't have the funding and resources to, and I see that as a major problem. I only raised the mandatory nature of that, but no, more's got to be done in that space.
Yep.
Otherwise, we're, especially with what's going to come through in later plans, it's just not going to be workable. So, you know, Mr. Logan may have to go to the politicians and say, you guys need to sort your act out. It's not good.
I don't think I've got anything to add to that. I think you're absolutely right. They, and from what I observe, Kaha really are oversubscribed with the amount of stuff that's coming in. So, yeah, any amount of support there, I'm sure, would be welcome.
I think I've pretty much covered everything I wanted to, because all the rest is already said it in my mind. But is there anything else that you might have, or I might have missed that you want to highlight first?
Probably not relating to the things that you've been raising. I did wonder if I might lay out at some stage, because we had the scope issue raised by Transpower. Of course, there's a legal dimension to that, which I'll leave to people wiser than I, but I thought I could perhaps lay out my thinking about inserting that too. So I think, as you noticed yesterday, we've got 2 submissions that ask for including ancestral land in MWP4. And that essentially, as you observed, could cover most of, if not all of, Otago. And my response to that, my section 42, was I'm comfortable to include more land to make this appropriate, but we need perhaps a bit more definition around that. And through pre-hearing discussions, we came up with the definition of Māori land. And I should add there too that I noticed going through yesterday that the definition of Te Ture Whenua Māori land hasn't been deleted in the current version. It should be deleted, as I recommended in my supplementary evidence. We're recommending it to be deleted. Once we agree that those are the kind of land, those are the kinds of land that should be included, then we have the option to just include those in MWP4, which would, from a drafting perspective, blow out the policy quite extensively. Or I think the cleaner option in those cases, because it is a definitional thing, is to put that into the definitions as a consequence. I realise that then has consequences for other policies throughout the RPS, which is perhaps where Transpower's concerns start to arise. My feeling on that is that the policy statement was drafted to be integrated and interconnected, and the wording chosen was a part of that. And so when we said Te Ture Whenua Māori land in MWP4, that was supposed to be reflected throughout the rest of the policy statement. So in a sense, that policy has tendrils throughout the policy statement. And my feeling is that when we change that definition there, to maintain the intended integrity of that term, it needs to proliferate throughout the rest of the RPS as well. And my fear is, if you don't do that, you start to end up with policies and provisions that are disconnected from each other. And in the worst cases, sort of, you end up with vestigial definitions and things that don't go anywhere and don't connect. And I think that when you consider one policy like that, you need to consider its wording, but you also need to consider it in place and in context. And that's why I think it's appropriate for that definition to apply throughout the RPS, not just in MWP4.
Thank you.
Thank you, James. I think everything's been pretty well traversed. So no further questions from me. Thank you.
Thank you.
You mentioned that on that issue that you've just addressed, that the reference to Turi Whenua and P4 was still there, but on my copy of the 11.
Oh, sorry, it's still in the definitions section. It hasn't been deleted from the interpretation.
Yeah. But in terms, if you look at your paragraph 34 of your supplementary evidence, you've made a number of references to the Turi Whenua Māori Act when in you got paragraph 34, right?
Sorry, just a moment. All right. So this 34.1 through 34.8, I inserted to be a record of the kind of lands that we had discussed including. Just to enable me to have a full discussion of the definition at hand. You'll note that the single definition, Te Ture Whenua Māori land, I've recommended that to be deleted from the RPS, and in its place is the definition of Māori land, which includes a number of sub clauses which do address land under Te Ture Whenua Māori Act.
So,
Māori land.
in terms of, I'm not sure what you've got as a version in front of you. You got the 11 October version in front of you?
I do.
Yeah. When you take us to the page number that you're saying should be deleted.
Yeah.
Oh, right, for sure. Oh, thank you. On page 51.
Right.
Hmm.
It probably does that version.
It seems.
My page 51 was related to wild economy.
Yeah.
Oh, right.
So every, sorry.
Yeah, mine too.
Have you got the 31 October?
That's one of the problems. We've only got 11 October.
Oh, right.
Um,
Sorry, what have you got on your page? It'll be.
So what you're trying to direct us to is, I think on page 48. You're trying to direct us to the definition of Te Ture Whenua Māori land, and you're asking for that to be deleted.
Yes.
Right, and replaced by the Māori land definition that you referred to in paragraph 41.
That's right.
Supplementary. Right.
Yeah.
Thank you. We got that clear. Now, just some more general issues if I can with you. Whilst we've got that paragraph 41 in front of you and that definition, can you just look at number 6? Can I just get some certainty from you? The qualifying words at the second part of that, which commence where the land was transferred or vested, is an entitlement or as part of an ancillary claim with 2 subclauses to that. Do I take it that that qualification, your intent is that applies to all of the land, i.e. the first option of held or obtained by Te Rūnanga or Ngātahu and or related entities, as well as including by a person or persons with whakapapa connection to Kaito. So the qualifications applying to all of that land. It's separate land, basically. Yeah.
Yes.
So in a way, it would be better to invert that and commence it with where the land was transferred or vested as part of a settlement, etc. Land and the land is owned by Te Rūnanga or Ngātahu, or and then I want to discuss the or with you actually, persons with a whakapapa connection. And then you've got to Kaito, but one of the thrusts of what we've been hearing about is that the whakapapa connection needs to be to the land. There's been quite an emphasis on that from the both the customary and the planning witnesses for Kaito. You accept that if you don't have that connection to the land, you're opening the opportunity for someone with whakapapa connection to Kaito living in Christchurch or Kaikoura or whatever, acquiring a piece of land, but being able to have the benefit of these provisions? You're saying it's both really, isn't it? So you've got a
Yes,
connection to Kaitohu and the land.
Yes, and I understand, and I have to confess that my understanding of the ins and outs of the land relationship is limited, certainly compared to the people we've had speaking to us previously. My understanding is that there is some land, because of the way that settlements worked out, that there might not be a direct ancestral link to that land that goes well back in time, but nonetheless, that is in fact the land that was granted to be used and in settlement for Kaitahu whānui. And so that connection to Kaitahu is vital to being able to use that sort of land.
It would be the Silna type land. would it be?
The at your paragraph 34, the wording used there, where, as I understand it, you're summarising what you were being requested to look at by Naito, had land owned by Turunaga or Naito or its constituent to Runa. But the one that you end up recommending has land owned by Turunaga or Naito and or related entities. Why did that change come about?
That, if you see down at where am I, at 34.7, that is the paragraph that relates to I suppose we call it clause 6 of the Māori land definition. That 34.1 was a separate request, and it's that Sandra has requested to be included.
Right.
My understanding of the reasoning behind that now is that is there because of the risks to existing land, because a lot of Māori land is coastal. It's at increased risk from erosion, and a lot of, as we've heard, a lot of land that was granted precisely because it was in undesirable places, some of which are subject to hazards or not usable. And this was inserted to help them find substitutes for that land, or if Papakayaka areas needed to be expanded, that they could be expanded. My feeling when I first addressed this was because the wording as it stands basically addresses any land that could be bought anywhere. I felt that perhaps that was too wide and too broad. But I am supportive of the reasons that were behind including it. I haven't found a better wording in the interim.
But basically what you're saying is I'm confusing 34.1 with 34.7.
Yes.
Yeah.
Yeah.
Okay. That's clear. The reference to, I think I probably want to take you to the Papakayaka definition. If I've understood the propositions being advanced by Kaitohu, concerns raised by other submitters in respect of control of what might occur under this definition should be met from a Kaitohu submission viewpoint by the control that is encompassed in the word, in the phrase, in accordance with tikanga Māori, and you sort of stressed that again this morning. But the word general, in general accordance with tikanga Māori, does that assist? How does it come about?
The general is included to address the issue that I alluded to before about tikaka and kawa potentially being viewed as frozen in time. That it permits some amount of flexibility and modernization of practices around tikaka and kawa, so that those concepts are able to continue to live through time. I can understand that the way it's phrased is quite general and lends itself to perhaps thinking that the connection to tikaka and kawa could be fairly tenuous. I feel that as I said before, I've erred on the side of taking Mana Whenua's interpretation of terms as the appropriate way to interpret those terms. My feeling of that term in the context of the provisions that it's used in is, and also my understanding of the way it would be applied by the people who are applying it, is that it's not a risk as it's currently phrased. Although I can understand why. I can understand the concern around it.
I may have misunderstood you in your answer to Mr. Cubitt, but I had understood you to be saying that you turned the regional council would turn its mind or had discussions about the possibility of resourcing funding, but as it stands at the present time, we are facing a method in M4, which as a mandatory matter is requiring, purporting to require the district councils to provide funding. And that hasn't changed in your recommendation. Going forward too.
Yes. I'm struggling to find a way to rephrase it that retains the emphasis on the importance of that resourcing, and also that addresses the issue that's been raised by Kaitahu time and again, that resourcing is really important to their involvement. I understand the concern about mandating particular resourcing, and this goes particularly to Waitaki's submission. What they wanted inserted, as I understood it, was a recognition that things would be that participation of Kaitahu would be resourced according to the size of the council. So I'm concerned about the quantum of any resourcing. But we don't actually talk about a quantum here. We say that it's, we simply say that participation must be resourced. I think all the councils in the area are doing that to a greater or lesser extent anyway. And I think it is important that that resourcing is enshrined as a matter of addressing or achieving the objective at the start of this chapter. So my feeling is that that must facilitate is appropriate. It's complicated a bit by the words that have been included to the extent desired by Mana Whenua. Once again, that's open to a reading of Mana Whenua can ask for whatever they so choose, and it must be delivered.
Just going to come to that.
Again, I've struggled with how best to word this. That is included almost for the opposite purpose. Because as you've raised, Okaha and Runaka are oversubscribed, and they simply don't have the capacity to be involved in everything everywhere all the time. And there was, I think this has come up for some years, a recognition of the risk that if you say you must involve them, then they get inundated with every issue that is under the sun, and they're not actually able to coordinate or prioritize their work in a reasonable way. So this is actually included as a protection for mana whenua to be able to pull on the handbrake if they need to do that.
Yeah, look, I think those are all questions that, and the other questions that Helen asked that I needed to ask. I just was going to raise with Mr. Logan, but we'd certainly be assisted, Mr. Logan, when you come to reply at the end of the hearings, if you could address as a legal matter this issue of mandatory requiring of funding by, or resourcing, but particularly funding by district plan provisions, but another issue in relation to that is, if as a matter of law we were to conclude that something couldn't be done, even no matter how desirable it might be, but if there's a legal barrier, a true legal barrier there, but there's no submission on that particular point, what should we do in that situation? And it would be a great assistance to us to have your input on that if we can.
Yes, I'll do that.
Thank you. Sorry, I wanted something else.
No.
Oh, it was just around the definition of Murray Land and. Oh, sorry, and I raised with Mr. Cameron with the various definitions that have been proposed and how the Papakite provision works around, for example, Ngāi forestry. And actually we're the ACC buildings, well, that's owned by, sites owned by Ngāi going up. How do they seem to suggest that they had to have the ancestral connection there, but I didn't read that the insertion that they wanted was any land owned by Trump or Runaka.
You're talking about the new insertion.
Yeah.
Yeah, that
Because
That
to me,
was
that
my-
opened it right up to Ngāi forestry to do what it.
that was my concern with that as well.
It didn't
I wasn't
seem
sure
like it was, but I wasn't sure around it.
Yeah, I didn't quite follow. I think my understanding from what Aidan said was that the forestry land is actually in the ownership of subsidiary companies, so it wouldn't be listed as owned by Front, and so it wouldn't be covered by the provision that they want to insert.
Okay, so and they're not, in terms of number 6, because it's not part of Treaty 7, or unless it was, they can't get in under 6 either, because it's got to have that connection to a treaty settlement.
That's how I understand it. Yes.
Yeah. But what about 7? And then, because the 7 and then the leasing issue that they spoke about. There's, yeah.
That's another one. I think having to have whakapapa connection to the land, in my view, probably rules out companies, even though they may be considered as persons for legal purposes.
But it was if you found someone that had that and then you leased it to Ngāi.
Yeah. So I think there are. I might turn to the least thing first and why I removed it. Least, in my view, is a term with really wide ambit. you can have a lease for a residential tenancy free flat all the way up to, as Mr. Campbell was talking about, Crown pastoral leases. And along that chain, there are some very different creatures indeed. And I was thinking I don't know an awful lot about Crown pastoral leases, but I understand that there's some quite strict rules around land use change there and who can do things with them, where actually the definition in an RPS probably wouldn't have that much influence over, in practicality, what you could do with that land. And my feeling in the end was, while I understand where the argument is coming from, that there are some terms of leases that look so much like ownership that they're probably pretty much indistinguishable. There's a huge range in the word leased. So I preferred it. I thought it was clearer with the statement that's there. I imagine through all of this, I think is in the nature of things, when you try to nail them down in this way, someone will always find a loophole.
Fellas over in the corner here.
It's there. And I tried to resist the urge to some extent to try and nail down every mouse hole, partly because I thought I would probably miss some, but also because throughout this section I acknowledge that there's some wording that could be open to interpretation or perhaps open to misuse. A lot of that would sit in the hands of the people that we've been hearing from, the people that we have a treaty relationship with. And I wanted, I suppose, to come at this section from a position of trust that Kaitahu Whānui, in particular Front and the Papatipu Runaka, through our relationship with them, we know, or we feel we know how they are likely to behave and how they are likely to treat these issues. And I believe that they can be trusted to be good caretakers of those provisions, I suppose I would say.
There's a big legal mind down there, so he'll sort it out. Thanks, James.
That's the bold approach that I think Ray Kitty was talking about. Thank you very much, Mr. Adamson. You've been very frank in your responses and given us good explanations for the conclusions you've reached. We've just got to grapple with whether or not we've reached the same conclusion. So I thank you very much.
Yeah. Thank you.
And I think that brings me to the last issue, which is just a timing issue of that was to be discussed last night.
Yes, so arising out of the panel's discussion yesterday with OGL, it became apparent that an enlarged or further evidence exchange was anticipated. So we had some discussions around that last night with OGL, and Council's understanding is that the relevant Section 42A authors are to respond to the amendments proposed by Fair Hunter as planning witness for OGL, sought by Fair Hunter, by the timetable that has been proposed with respect to supplementary evidence on the MPSFM, which was, I think, 24 February.
Yes.
And those authors are able to do that.
Right.
So we can confirm that timetable.
Thank you very much.
Just on a separate matter, sir, for when we recommence, if it's helpful, I will make you all a copy of the
Yes.
October, which is the latest version that we're all working from.
Right.
And,
Thank you.
if you're with that.
Yes, indeed.
Yeah, wonderful.
I think Mr. Constantine might have that underway.
Oh, look at that, Peter. Thank you.
Thank you very much. And, so the minute that will issue, the only concern we got probably, I suppose, out of that timing is just in terms of the bigger picture of whether we restrict Oceania Gold in terms of any response they have, because that timetable we'd set for 24 February then had a response time of 31 March, and that's all right for the fresh water, actually, yes. But we wondered in looking at that timetable whether that would mean the integrated management aspect of it, which is coming up a bit earlier than that, would be impacted. I suppose in a way we can just necessary leave that side of it to be dealt with in the later hearing after we have the responses. That seem workable to you?
Yes, and I guess with respect to the 42A authors, very much like you said yesterday, it depends whether they say, oh, well, you know, I've addressed this and I've got nothing more to say, or whether, you know, genuine, of course, they'll analyse it. Some reworking is done in the light of the amendments to the HPL and the, well, coming into force in national policy statement. So, yeah, it's going to might be a bit of a moving feast.
All right. Well, look, I think it rather than getting a whole number of different dates that we can work with, specific a set of dates that we've got at the present time, we'll try and work around whatever is necessary. So the dates that I'll hand to Kate to put into the minute will be those dates, 24th February for the report writers, 31 March for any response by Oceania Gold. Right. Thank you.
Thank you.
Thank you very much. All right. Well, that concludes the hearings for this week, and we reconvene again on the 7th of February.